a multi-million rand real estate portfolio. You've sacrificed, you've saved, you are completely debt-free.
Right.
And then a single slip and fall accident on one of those properties legally bankrupts you and, well, takes your family's home.
Right.
Why? Because you committed what might be the ultimate financial sin.
You put your own name on the title deed.
Exactly. You put your name on the deed.
It is a really jarring reality check. I mean, for anyone listening, we are conditioned from day one to accumulate assets, but almost no one teaches us the actual mechanics of how to properly hold them.
Which is exactly our mission for this deep dive. Today, we're exploring the ultimate legal cheat code for protecting your wealth and isolating your assets from risk. We're pulling our insights from two incredibly detailed sources. First, we have a comprehensive manual called Strategic Real Estate Protection, the Land Trust Guide. And second, we're looking at the practical methodologies of South African trust consultant Lumka Sturman.
Yeah, and whether you are a small business owner, maybe a property investor, or just someone trying to build a solid nest egg, you really need to understand the architecture of ownership.
Okay, let's unpack this. Why is direct personal ownership such a catastrophic vulnerability?
Well, the fundamental flaw in personal ownership is that it creates total visibility and inescapable liability. So when you purchase a property or register a business asset in your personal name, that information instantly becomes a matter of public record.
Right.
In South Africa, anyone with access to the deeds registry can just, punch in your ID number and pull up every single property you own.
Which means an opposing attorney doing a basic asset search can calculate your approximate net worth in what, a matter of minutes?
Exactly, minutes.
You're essentially walking through a high-risk neighborhood wearing a T-shirt with your exact bank balance and home address printed right on it, You're broadcasting your net worth to potential litigants, creditors, disgruntled business partners.
Or even just curious competitors.
Yeah.
And that visibility is dangerous enough, but the true vulnerability is how it mixes your personal liability with your business liability.
How so?
Well, think about how many entrepreneurs sign personal sureties or guarantees just to get their businesses off the ground.
Oh, yeah, all the time.
Right. If a commercial deal goes sour, or going back to your opening example, if a severe injury occurs on a property you own personally, the resulting lawsuit doesn't neatly confine itself to just that one business or that single property.
Because your name is the common denominator.
Precisely. Your name links everything together, so your entire portfolio gets dragged into the firing line, your private bank accounts, your family's primary residence, your retirement investments.
Wow.
Yeah, wealth preservation is rarely just about generating revenue. I mean, it requires building a structural barrier that quarantines your wealth from the daily inevitable risks of operating in the real world.
So if personal ownership is a ticking time bomb, how do the ultra-wealthy actually structure their lives? Because they clearly aren't walking around with targets on their backs.
Yeah, definitely not.
When I was going through Lumka Sturman's methodology in our sources, she refers to this solution as building an asset protection fortress.
Yes. The fortress.
And the foundational rule of this fortress seems elegantly simple. Like, your trust owns the assets and your operating company carries the risk. Is it really that straightforward?
That separation between ownership and risk is the absolute core philosophy. And the vehicle used to achieve that separation is the trust.
Okay.
To understand the mechanics, we have to look at the three distinct roles within this structure. First, you have the founder or donor who establishes the trust and moves assets into it.
Got it.
Second, the trustees who legally hold and administer those assets according to the rules of the trust deed. And third, the beneficiaries. Those are the individuals who ultimately receive the income or capital from those assets.
Now, here's where it gets really interesting. I want to pause here because this is the exact moment where most people hit a mental roadblock.
I know exactly what you're going to say.
Right. If I take my hard-earned capital or my real estate and I legally transfer it into a trust, I don't own it anymore. I've essentially lost control of my own money.
That is the most common hesitation by far, but it stems from a misunderstanding of what ownership actually means. The brilliance of the trust structure is that, yes, you are surrendering direct legal ownership, but you are not sacrificing practical control.
Wait, really? How does that work?
Or financial benefit, for that matter. You can serve as a trustee, meaning you are at the steering wheel making the management decisions. Concurrently, you can be named as a beneficiary, meaning you receive the financial upside.
So the legal title sits with the trust entity, but I am still the one deciding when to sell, when to buy, and I still get the rental income.
You've hit the nail on the head. From the perspective of the public registry, the trust owns the building. You merely hold a beneficial interest in the trust. And that legal chasm between legal title and beneficial interest creates one of the most impenetrable shields in asset protection. It's known as the charging order limitation.
I was actually reading up on the charging order limitation before we started recording. It strikes me as being somewhat similar to, like, a hostile takeover in the corporate world, but one where the attacker gets shares, yet is legally stripped of any voting rights and barred from receiving dividends.
That's a great analogy.
Correct me if I'm wrong, but if a creditor sues me personally and wins, they can't just force the trust to liquidate its assets to pay my debt, right?
This is the precise mechanism at play, yeah. If you owned a property directly, a creditor with a court judgment could simply attach a lien to your house and compel a sheriff's auction to recover their funds.
Which is terrifying.
Absolutely. But when a trust holds the legal title, the property isn't yours to sell. The creditor cannot breach the trust's walls to force a liquidation.
So what can they do?
The absolute most they can secure from a judge is a charging order against your beneficial interest.
And what does that charging order actually do in practice?
It basically functions as a legally mandated redirection of funds. The court order essentially dictates if and when the trustees decide to distribute cash to this specific beneficiary, that cash must be diverted to the creditor first.
Wait, if and when?
Yep.
Well, as the trustee, I could just look at that charging order and decide, well, we simply aren't going to make any distributions this year. We'll reinvest all the rental income back into the trust's property portfolio instead.
You absolutely could.
Wow.
The creditor cannot interfere with the internal operations of the trust at all. They are left holding a piece of paper that entitles them to money you have no obligation to distribute.
That is incredible. The creditor's forced to just sit outside the fortress and starve. I mean, they still have to pay their own legal fees, they're wasting time, and they have absolutely no guarantee of ever seeing a cent.
Which creates an immense amount of negotiating leverage for you. Faced with the prospect of waiting decades for a payout that may never materialize, creditors will routinely settle for a microscopic fraction of the original judgment just to close the file.
Let's ground this theory in the real world, because the Land Trust Guide source provides some highly specific scenarios of how this operates, particularly in real estate.
Yeah, the case studies are great.
I want to look at the privacy element first through the case study of David Morrison.
The commercial portfolio owner.
Yes. So the guide outlines that David held 85 million rand worth of commercial real estate. Originally, all of that was registered in his personal capacity. A quick search of the deeds registry would light up like a Christmas tree.
Highly visible.
Exactly. But he restructured. He moved those assets into a series of trusts using intentionally mundane, generic names, things like DMC Trust Number 1, DMC Trust Number 2, and he utilized a corporate entity to act as the trustee. Virtually overnight, his personal name was erased from the public property grid.
And we see the strategic value of that privacy during his subsequent legal battle with a former business associate.
That's the most fascinating part of the case study to me. The disgruntled partner's legal team initiates the lawsuit and naturally conducts an asset search to see how much they can squeeze out of David.
Right, looking for the deep pockets.
Exactly. They check the registry, and his name yields 0 results. They genuinely believe he has minimal personal wealth. Consequently, they accept a relatively minor settlement out of court.
Wow.
If they had known about the 85 million rand war chest, they would have litigated aggressively for years.
It perfectly illustrates that privacy isn't about deception. It is a proactive defense strategy. An attacker is far less likely to launch an expensive legal campaign if they can't verify that a lucrative prize exists at the end of it.
Makes total sense.
But the strategy extends far beyond obscuring your net worth. It is fundamentally about liability isolation. We see this really clearly in the second case study, Jennifer Campbell.
Right, the residential investor. She owned 12 different rental properties. Now, instead of lumping all 12 into one giant family trust, she utilized the portfolio approach. She established 12 separate trusts, one for each specific property.
Which seems cumbersome until you understand the risk mitigation.
It's like engineering a ship with watertight compartments.
Exactly.
When a tenant's guest suffered a severe injury at property number 4, sparking this massive 3 million rand liability lawsuit, the legal flooding was entirely contained to that single compartment. The lawsuit could only target the assets held within that specific trust.
Meaning the other 11 properties, held in 11 distinct legal entities, were completely insulated from the fallout. Her broader wealth remained untouched.
That's brilliant.
And it goes even deeper than defensive tactics. Structuring assets this way unlocks incredible operational agility. For instance, if you decide to sell one of those properties, you don't necessarily have to execute a traditional real estate transaction.
Right, the guide mentioned you can simply transfer your beneficial interest. Walk me through the mechanics of how that actually works.
Sure. You are transferring the rights to the trust, not the physical real estate. The property itself never changes hands. The trust remains the registered owner on the title deed.
Okay.
What you are selling through a private contract is your position as the beneficiary of that trust.
So the buyer pays me, I step away, and they step into my shoes as the person who receives the income from the trust.
Correct. Because the registered owner of the property the trust hasn't changed, there is often no requirement to record a new deed in the public registry.
Oh, wow.
Yeah, this keeps the transaction entirely off the public radar, speeds up the handover process significantly, and in certain jurisdictions, it can even alter the transfer duty implications.
That is a phenomenal strategic advantage. But we need to pivot and talk about the specific rules of the game depending on where you are playing.
Yeah.
Because while these overarching principles apply globally, the specific legal architecture varies wildly by jurisdiction. For our listeners operating in South Africa, Limke Sturman's insights are indispensable.
Absolutely.
How does the South African legal landscape dictate the way we build these structures?
Well, within South Africa, asset protection generally relies on two categories of trusts. Testamentary trusts, which are drafted into your will and only spring into existence upon your death.
Right.
And living trusts, or inter vivos trusts, which you actively establish and operate while you are alive. If you're building an asset protection fortress today, you are utilizing a living trust.
But there is a very stringent compliance rule in South Africa regarding family trusts. I'm talking about the requirement for an independent trustee.
Yes. South African trust law dictates that if a trust is established for a family and the trustees are all beneficiaries or related to one another, you must appoint at least one independent trustee.
Meaning someone who is not you, not your spouse,
Yeah.
and has absolutely no vested financial interest in the trust's assets. Why on earth would I want a complete outsider holding veto power over my family's wealth?
Because without that independent oversight, the courts will not recognize the trust as a valid, separate entity. The independent trustee is basically the structural steel that proves to a judge, or to SARS, the South African Revenue Service, that you have genuinely relinquished direct control.
Okay, I see.
If you, as the founder, simply use the trust's bank account to pay for your personal groceries without consulting anyone, you are treating the trust as an alter ego.
And that leads to the concept of the sham trust, right?
It does. A judge isn't just looking at the trust deed, they are scrutinizing the paper trail. They want to see minutes of trustee meetings. They want to see formal resolutions drafted and signed by the independent trustee approving the purchase of a new asset or the distribution of funds.
So if you don't have that,
If that administrative rigor is missing, a judge will pierce the veil of the trust, declare it a sham, and treat all those protected assets as your personal property ready to be seized by creditors.
so the independent trustee is basically the immune system of the trust.
That's a good way to put it.
Okay, speaking of SARS, we have to tackle the taxation element. When I reviewed Limke Sturman's breakdown of South African trust tax rates, I legitimately thought there was a typo in the research.
People always do.
Income retained within a South African trust is taxed at a flat rate of 45%, and the effective capital gains tax rate sits at a staggering 36%. I have to push back here. Why would any rational investor go through the complexity and expense of building this legal fortress only to hand nearly half of their yields straight to the taxman? That sounds like a terrible deal.
It seems highly counterintuitive until you dissect the concept of retained income. That 45% punitive flat rate only applies to capital or revenue that the trustees choose to leave sitting idle within the trust's bank accounts at the end of the financial year.
But there's a workaround.
Well, it's not so much a workaround as it is a foundational feature of trust law called the flow-through or conduit principle. If a trust generates, say, 100,000 Rand in rental income, the trustees can resolve to distribute that income directly to the beneficiaries within that same tax year.
And once it flows through to the beneficiary, it loses that 45% trust tax rate.
Completely. The income retains its nature as it flows through the trust and is taxed in the hands of the beneficiary at their personal marginal income tax rate.
Oh, I see.
Yeah, so if your beneficiary happens to be in a 25% tax bracket, the tax paid on that 100,000 Rand is calculated at 25%, not 45%. It provides trustees with a strategic dial they can adjust annually to optimize the family's overall tax burden.
That makes vastly more sense. So the 45% is basically just a penalty for inefficiency.
Exactly.
But the sources point out that the real heavy-hitting tax efficiency for wealthy South African families isn't necessarily about dodging annual income tax. It's about optimizing the transition of generational wealth.
It is about neutralizing estate duties and the devastating administrative friction of death.
Let's break that down. In South Africa, when someone passes away, their estate has to be reported to the Master of the High Court for estate administration.
And that administration process is incredibly traumatic for an unprepared family. When you die holding substantial assets in your personal name, your bank accounts are frozen.
Just frozen entirely.
Frozen. Your dependents cannot access cash. The master appoints an executor, and the winding up process can take anywhere from 18 months to several years.
During which time, family businesses can collapse due to lack of operational capital, and properties can fall into disrepair.
Oh, easily.
Not to mention the executor fees and the hefty estate duties levied against the total value of your personal assets.
Right. Now contrast that with a trust structure. A living trust does not die when you do. Because the trust legally owns the assets, your death is largely a non-event from an ownership perspective.
That is wild.
You simply fall away as a trustee. The remaining trustees seamlessly continue managing the portfolio. The income continues flowing to your children or dependents without a single day of interruption.
So you completely bypass the Master of the High Court. No frozen bank accounts, no multi-year administrative delays, and because the assets aren't in your personal estate, you structurally mitigate estate duties across multiple generations.
It ensures that the wealth you spent your life building actually serves your family when they need it most, rather than being ground down by legal machinery.
Which brings us to the execution phase. We've established that personal ownership is a critical vulnerability. We've mapped out how the Asset Protection Fortress isolates liability, secures privacy, and optimizes generational wealth transfer in South Africa. The logical next question for anyone listening is, how do I actually implement this? Can I just find a template online, register it, and call it a day?
Attempting a do-it-yourself approach to trust formation is the fastest route to financial catastrophe.
I figured as much.
If you use cheap, boilerplate templates, you are almost guaranteed to fall into the sham trust trap we discussed earlier. You will fail to embed the proper checks and balances, and you'll lack the administrative architecture required by the CIPC, the Companies and Intellectual Property Commission, and SARS.
Which means the moment your fortress is tested by an audit or a lawsuit, it collapses like a house of cards.
Yeah.
All that effort is entirely wasted.
Exactly.
And this is why our source material heavily emphasizes Lemke Sturman's specific methodology. She operates as a trust consultant and asset protection specialist. But reading through her approach, she isn't framed as someone just pushing legal paperwork. She acts more like an educator and a structural architect.
The architect analogy is highly accurate. You are not purchasing a static document. You're engineering a dynamic legal entity that must interact with corporate registries, revenue services, and banking institutions.
Her methodology reflects that complexity, too. It begins with what she calls a foundation audit. Before any documents are drafted, she analyzes the specific terrain of your life. She maps out your personal risk versus your business risk, evaluates the assets currently exposed in your personal name, and determines if a trust structure is even financially justifiable for your specific situation.
Right. And if it is justifiable, the process moves to the blueprint session. This is the architectural design phase, creating a South African compliant ecosystem. Often, this involves structuring a Krishi Ltd, a private company, to absorb the operational business risks, while the trust safely holds the underlying capital assets and shares.
Your operating company takes the hits, your trust holds the gold.
Exactly.
And perhaps the most vital component she offers is the Fortress Checkup, because the legislative landscape is constantly shifting. CIPC beneficial ownership regulations update, SARS reporting requirements evolve. Having a specialist maintain the ongoing compliance ensures that when the audit notice arrives or the lawsuit is filed, the walls of the fortress actually hold.
It is fundamentally an investment in certainty, translating dense statutory requirements into practical security.
If you are listening to this and realizing that your life's work is currently sitting out in the open, fully exposed to the elements simply because it's attached to your ID number, You really need to explore these concepts further.
Highly recommend it.
Limca Sturman has built resources specifically to help small business owners, consultants, and professionals bridge this knowledge gap. You can find out if a trust is right for you or grab her toolkit by visiting her website at www.limcasturman.com.
Education is the first line of defense. Understanding the mechanisms of protection is just as critical as understanding the mechanisms of profit.
So let's bring all these threads together. We began by confronting a hard truth. The traditional milestone of putting your name on a title deed is actually a massive liability. It broadcasts your financial position and permanently intertwines your personal security with your business risks.
We then dismantled the myth that trusts require you to lose control of your wealth. By legally separating title ownership from beneficial interest, you utilize mechanisms like the charging order limitation to basically starve out creditors, all while maintaining practical command over your portfolio.
We analyzed real-world applications, seeing how multiple trusts can create watertight legal compartments to quarantine lawsuits, and how transferring beneficial interest can keep your transactions entirely off the public grid.
And we contextualized all of this within South Africa. We tackled the intimidating 45% trust tax rate, revealing how the flow-through principle allows for highly efficient tax management.
Yep.
Most importantly, we explored how removing assets from your personal name bypasses the grueling estate administration process under the Master of the High Court, preserving your capital and continuity for the next generation.
All of which underscores the absolute necessity of rigorous administration and independent oversight to avoid the catastrophic failure of a sham trust. Utilizing an expert architect to design the system isn't a luxury, it's a prerequisite for it actually functioning.
To wrap up our analysis today, I want to leave you with a perspective shift to mull over. We spend decades trading our most finite resources, our time, our physical energy, our focus to accumulate capital. We sacrifice endlessly to build these portfolios, but what if the greatest threat to your family's financial legacy isn't a global economic downturn or hyperinflation or even a bad business decision?
What is it then?
What if the greatest threat is simply the stubborn, ingrained belief that if your name isn't on the public registry, you don't really own it?
Oh, wow. That's a profound paradigm shift.
True wealth has never been about what you own on a piece of paper for the entire world to scrutinize and attack. True wealth is about what you quietly control and ultimately what you are capable of protecting.
That is the perfect note to end on. It completely redefines the concept of a title deed. Thank you so much for joining us on this deep dive. Take a hard, critical look at how your assets are currently structured, start gathering the blueprints for your own fortress, and we will catch you on the next one.